Um, Hello, everyone. And again, thank you for inviting me to this excellent workshop. I thought I'd start with maybe a little vignette. I was representing a client once in some remote part of Alaska, and I saw from the documents that I received from the prosecutor that my client had admitted to the crimes. When I met with my client, who was in jail at the time, I asked him what happened, and he denied ever being involved. When I confronted him with the fact that in the police report, it indicated that he had given a statement where he admitted to what he had done, the client said absolutely not, that he had in fact denied being involved, and that he had told this to the interpreter. So based on that, I confronted the interpreter and I asked him, point blank, what did the client said? To which the interpreter said, well, he denied being involved, but we all know that he was involved. So I just said that he did it. Now, it's a real life story. Here's a situation where the interpreter had a tremendous amount of sway of what might happen to this particular person's, future. And I make the point because of what I've been hearing so far today and what we talked about yesterday as well, is how important interpreters are when it comes to dealing with minorities or with anyone who speaks a different language, and you're relying on the interpreter for accuracy. And even when they speak the same language, it's not a given that you're going to get accurate translation. And sometimes, as I was in a case where Swahili, for instance, was the language, and my client was from Kenya, but the interpreter was from Tanzania. And there are some slight, differences. There are nuances. And so one term may have a different meaning entirely. And thankfully, it was the client that brought it to my attention that actually they were using the wrong interpreter. And that helped figure out a solution. So anyway, that's just an aside on that, but we'll talk more about that. I'm going to give you a sort of the perspective from a trial lawyer who has actually been dealing with this stuff on a regular basis, both at the national and the international level. But I want to focus primarily on one or two cases to show you how I went about in applying a lot of the things that we talked about yesterday, as far as meeting your client for the first time and how do you conduct that interview. And then, of course, how you put together what I call the theory of the case. How is it that you're going to be defending this particular individual? Because you have to have a theory where you explain why your client is not guilty, or why perhaps if he is guilty, there are mitigating circumstances which would allow for a lighter sentence, or why there may be some defenses. While there may not be a total defense, a partial defense would provide for a lesser charge and a lighter sentence. So since we're talking about culture, if we go to slide number 2, just some general principles, on the impact of culture. Culture shapes our values, attitudes, and norms. I mean, I can't overstress this because when you hear of somebody's culture, and you have any, if you have even a passing knowledge of it, you automatically may jump to some conclusions when you may not necessarily know everything there is to know about that particular culture, but based on your perceptions, your attitudes, and your own values, you may jump to certain conclusions. It is the lens through which we judge people. and I think that's terribly important, because as you begin to work on a case, you realize how much perception comes into play, okay? And a lot of that, of course, your perception may be shaped by your own culture, because you may be ignorant of the other culture that you're dealing with. And that's why having a shared culture tends to improve our predictions and interpretations of human behavior. So it's a lot easier, for instance, to say, well, someone from this particular part of the world where I come from would behave this way. And this behavior here is totally out of character. Whereas if you're dealing with somebody from a foreign culture that you're not familiar with, that behavior may be totally acceptable and totally understandable under the circumstances. And then the question that you might have to resolve is, be that as it may, within the framework of the law by which this person's conduct has to be judged, what can you do with it? Is it a complete defense, or is it a partial defense? Is there some kind of a justification that you can argue? If we go to the next slide, okay, so this would be slide. The cultural differences can impact the judge's perception of a client in several ways. And that's important also, because I always see trying a case and representing a client is like being a salesman, a salesperson. You're selling a product. The product is your client and your client's case. And of course, who's buying that product? It's the judge or the jury. So you have to be able to convince this judge that the product that you're selling is a good product. So that's how I look at it from a very practical point of view. So I ask myself, what is the judge perceiving? Whether it's from the body language, the story that the person, the client says. As I said, in the events as described by the client may be perfectly legitimate and plausible. But because, as I indicated yesterday, the judge may live in a different world, it's beyond his or her comprehension, unless, of course, you're able to transport that judge, get him to suspend reality as he or she knows it, based on his or her environment. Let them enter into your client's environment, let them figure out, see what it's like to be your client, what it's like to work with within his culture, and then based on that, to make an evaluation on whether the client is being truthful, honest, whether he or she has credibility, and what have you. If we go to the next slide, and that would be, I think, slide number 4, or we talk about, language. I think I just discussed that. If we go to slide number 5, effective cross-cultural interactions, whether with the client or the judge, require you to be aware of potential errors, to compensate and to learn from your mistakes. Okay, so that's just a general concept. So what is it that I do, at least, when it comes to dealing with a client where he comes from a different culture? And sometimes it doesn't even have to be culture. It could be someone who has certain disabilities, someone who has certain experiences that are different from the rest of us. And it's something that would impact the way they perceive and they go about making decisions. So I ask myself, okay, what culture does the judge come from? And how different is that culture from my client's culture? What can I do to influence the judge's decision? That's important. What sort of information does a judge need to understand and to allow him to make a proper decision for my client? How can I obtain this information? Where is it? Where can I go to get that information? How can I present this information to the judge? How can I deliver it in a way that it is cogent, that is clear, that is consistent, and that is understandable? So those are the sort of things that I ask myself, because I'm trying to put together, I said, a theory of the case. It's the theory as to why my client is not guilty. And it has to be a plausible theory, not just a possible theory, a plausible. In other words, that it has to be something that is very realistic and very understandable and plausible given the client's culture, experience, background, and of course, the facts of the case. So those are the sort of things that I look at and I think about. And yesterday we talked about the importance when you meet your first client, when you meet your client for the first time, how important it is to go there a little prepared. So if you go to slide number 6, we talked about prior to your initial interview, you have to immerse yourself in your client's culture. Of course, sometimes it's not possible. You may have to do that afterwards. But one of the things that you need to understand, or you need to appreciate, and it's hard sometimes to do that, is to know what you do not know. Because most of the times we don't know what we don't know. We make assumptions that we know something. So if you have a chance in advance to know, excuse me, that your client comes from a different culture, and then you might want to try to figure out, okay, what is it about this culture that I need to know to familiarize myself, to be able to communicate with my client, but then eventually, two, to be able to communicate the client's case to the court, to the judge, in order to get the best possible outcome out of the case. And that's where you need to begin to consult with experts, start reading, do whatever it takes to really understand the culture. Sometimes I find reading short stories that are written about, that have been written either by those people within that culture, or stories that are passed down. Anything that I can figure out, how is it that these folks process information? What is it that makes them tick, in a sense? So now I'm going to give you a couple of examples, and I'm going to start off with the battered woman syndrome case. I think this is an excellent case for our purposes for today. The client was an Aleut native. She was from the, I was practicing law at the time on an island called Kodiak. It's right by the Bering Sea. And the client was living in a very small village, very isolated. You could only get there by a small plane. And so on Kodiak Island, even though it's a fairly large island, it has little villages, and all these villages are remote, and each village has its own characteristics. But the natives there are primarily the Native Alaskans. They are Aleut. Very, very different from what I told you about my client from up north, the one who had killed his uncle. So she had stabbed her husband, as I indicated, when he was passed out. Well, the first question I had lived in Kodiak for a while, so I sort of understood the culture a little bit, but I really didn't understand. I never had to run a cultural defense, or at least make that part of my overall defense. So I needed to understand a little bit about the Aleut culture, but also about the particular culture in this particular village, how they operated, how they worked, how they intermingled among themselves. Because this woman for years had been battered, she had been beaten, And at one point, we had a witness who had indicated that she was being beaten in the street with a fairly heavy stick, and nobody went out of their house to assist her, even though they could hear her scream and they could hear her being beaten to the point of nearly being half dead. No one went out of their way to do that. So I had to figure out something. So I began by going to the library, looking up everything I could find about that, and then actually talking to some cultural anthropologists, folks that had actually studied them. And then I went of course, I met with a client, I spoke with a client. And again, in dealing with clients from a different culture, you have to be very, very careful in not making assumptions. You may ask a question, or you may give information to the client and then ask them, well, do you understand? Or if you don't understand, please let me know. And so a lot of times, at least in Alaska, you would find yourself where when you ask the client to tell you if they didn't understand something, they would just look at you, literally just stare at you in the eye and not say anything. And one of the reasons is they don't want to embarrass you, because obviously if they have to tell you that you weren't clear enough to them, it's as if they're criticizing you, or they simply, it's not within their nature to admit that they don't understand something. So they may say, yeah, a yes, or they may just nod their head. And you take that as an indication that they fully understand what it is that you tried to convey, when in fact, they really didn't understand a whole lot. And that's why what I try to do is I try to, when I'm trying to work with someone and I'm trying to get a point across, I deliver it on several different ways, on several different occasions. Again, it's repetition in a sense, but to make sure that, they try to get as close, they try to understand me as much as possible. And even then, I'm not certain. And if you're dealing through an interpreter, it becomes even more important, because one, you're relying on the interpreter. Two, sometimes these languages don't, the legal terms don't translate properly. So you have to work with concepts. You have to make sure that the interpreter gets it. And so a lot of times what I would do is spend time with the interpreter, so they understand key phrases, what they mean, because they may not be familiar. It's not always possible to have a professional interpreter who's court certified. So you're dealing with somebody, then you have to explain to them through maybe a concept what exactly this term means, and then to allow the interpreter to understand and maybe ask you a few questions, and then begin the process. And even then, you're not quite sure, so you have to sort of like ask questions and try to get some answers to figure out whether they really understand what it is that you're trying to convey. So in this instance, language was not that much of a problem, but what was a problem was, of course, the defense that we were running was self-defense based on what is known as battered woman syndrome. So we needed an expert, and we were able to find an expert, but as I indicated yesterday, a lot of the tests that are done for white Caucasians, and so it may not necessarily be applicable for an Alaskan native from this part of Alaska. So having one general expert to sort of convey the concept of battered woman syndrome is one thing, but then we were able to find someone from Kodiak who actually had a degree in psychology, and had in fact herself been treated for battered woman syndrome. And she was very familiar with the village. She was from Kodiak Island. So she was able to give a local perspective to the judge, who was a Caucasian, was not from Kodiak, and obviously did not know anything about the village. And so part of the defense was not just talking about the events, how they transpired, but also talking about how life on the village is and how people interact, why someone would not interfere in a situation where somebody is beating their wife to death, because it would be, that's considered a family matter. You don't interfere with family matters. And so even though the one witness we had was the brother-in-law, he could hear his sister-in-law begging for help. And when he got up, he at one point he indicated he tried to get up from the bed, and his wife, of all people, who was friends with my client, said, don't get involved. That's a family matter. And it was important to get that across. Of course, we were trying to persuade jurors as opposed to a judge, but it's the same principle. But they really had to understand why it was, how things operated, and why perhaps this woman felt trapped. And even though she could have walked out the door when the husband was passed out, there was no place for her to go that it would haunt her. There were other issues as well, such as sexual violence or, sexual abuse when she was a minor by her own father. And that had to come out. And there, that was a very important aspect of the defense, because that was what, that affected the way she processed information and how she interacted and what have you. And it fed into the post-traumatic stress disorder that she was suffering from, plus battered woman. And it was necessary to get that out. But how do you get the client now to admit that, and to admit it publicly? Because it's a public trial, and all of this has become public, and she has to go back to live in the village. And so trying to get the client to understand that while this is a very private issue, this has to come out. And then when you get all of that out, you still have to convince the judge or the jury that that you're not just throwing that out there for sympathy purposes, but actually there is a connection. There's a linkage. So you have to link all of it together. So when you're dealing with a cultural defense, you have to make sure that you're linking the conduct, with the culture. And otherwise, it doesn't make any sense. Or at least it won't have much of an impact to the judge. You need to convey to the judge that your client is behaving within his or her culture and within his and her experiences. And so I don't see, from my professional point of view, there's not much difference between defending someone in a complicated case where the person has peculiar experiences that might impact the way he or she thinks, and a cultural defense. It's virtually the same. The only difference is you really need to immerse yourself in the culture, and you really need to be able to communicate to the judge how the culture is actually impacting on the client's behavior, his actions, and how perhaps given, the culture, the client really never didn't commit the crime, or maybe committed a lesser crime. So yesterday, as you may recall, I talked about the gentleman in Ratanakiri who had killed his neighbor in self-defense because he believed that the neighbor had put a spell on his son, and his son was died from that spell, and that if he did not kill kill his neighbor in self-defense to defend himself and his family, that the neighbor would proceed with putting spells on the rest of the family. Now, as I indicated, if you had run this defense in Phnom Penh, the capital, and if you're dealing with a judge who was not terribly sophisticated with the various minorities, in various parts of Cambodia, and especially that particular minority, what you would have to do is you'd have to educate the judge. So you would have to bring in maybe a cultural expert to show how, for instance, in this minority believes in these spirits, believes that individuals have the power to put spells and so on and so forth. And then you have to tie it up to show that, in other words, you have to demonstrate that the client actually believed that this is what happened, which is why he did what he did. And in doing so, you may have to exclude other possibilities. In other words, that perhaps the client did not have any prior incidents with the neighbor, did not have any other motive, did not have any other disputes. There was no other reason why your client would act this way against his neighbor, save for the fact that he believed in this instance the neighbor had put this spell. So it's not just throwing out, well, they believe in this, and this is what he did. Now, why is that important, though? It's important because if you're charged with murder in the first degree, with intentional murder, where the mental element is intent, well, it may go a long way if you're putting in this cultural defense to demonstrate that the client never really had the intent, the requisite intent in this particular instance. So why he did what he did, there is some sort of a cultural defense which would mitigate. In this instance, it would not absolve 100%, but it certainly would mitigate it. Yesterday, I talked about the young man who had staged the fake armed robbery in the store to prove a point. Well, if you need the requisite mental state of intent, and you can show that he lacks it because he's suffering and because of his perverse way of thinking, which is how sometimes cultural defenses are perceived by the judges, then you can make the argument that, well, he didn't have the intent and therefore he could not be guilty of the crime that is being charged. So essentially, this is how I go about defending someone with a cultural defense. I immerse myself into the culture. I try to understand how they think. I try to read, stories about, in fact, when if I'm dealing with a jury, I try to weave those into my closing argument, or try to, by way of analogy and what have you. But the essence is, you really have to set aside how you think, how you would behave. Recognize that the judge has to do the same thing. Recognize what it is that you need to provide the judge in order to understand your client. In other words, you need to give him the necessary information so that you can put the events in a proper perspective. And you cannot do that unless you have the necessary information. With my client up in the north part of Alaska, in Barrow, who killed his uncle, he had no reason to kill his uncle. They got along very well, but what happened? They were drinking. They were drinking to the point where he blacked out and couldn't remember a thing. All he remembers is the next day he found himself in jail and learned that he had killed his uncle in the meantime. Now, there have been studies that Native Alaskans black out when they drink a lot. And so in this instance, you need to bring in someone to show that these particular natives are susceptible to blacking out after they drink large quantities of alcohol. There have been studies, psychological studies, and and what have you. And so you have to demonstrate that. And then you have to prove, of course, that there was lots of alcohol being drunk, and that perhaps is not so difficult because if you have 10 bottles of whiskey that are empty, that might explain it. And then then you can begin to argue, for instance, that because he blacked out in this instance, he didn't have the requisite mental intent to kill. Doesn't mean that he's not guilty of something, but he's not guilty of intentionally killing his uncle. So we're looking at something lower. And then when you look at, for instance, in that part of the cultural defense was the impact that it had on the family, the fact that the father and the mother of the deceased were willing to forgive. That plays an enormous amount of importance in the judge's finding as far as what sort of sentence should be imposed. And especially if you can get other members of the community to do the same thing, to say, well, we forgive him and what have you, because they understand that that's part of their culture, that he or she's going to suffer enough. But the fact that there is forgiveness in this particular culture, because you can give a lighter sentence. And just to give you an example, murder in the first degree in Alaska was almost an automatic 99-year sentence. 99 out of 100 times you would get 99 years. If you got it down to second degree murder, you're looking at maybe a 30 or 40 or 50-year sentence. If you got it down to manslaughter, that you behave recklessly, then you could get maybe a 15 or 20-year sentence. And that's what we got it down to, that we were able to show that he didn't have the mental capacity at the time for intent. The family forgave him based on the culture and everything. And as I indicated to you earlier yesterday, it took 3 or 4 times for me to meet him before the client actually would open up and begin to describe what happened. And I would not have been able to achieve what I achieved had I not had the experience and the wherewithal to consult with our very experienced translator, who I use as a cultural expert to educate me on the culture and how I should approach this particular individual. I think I can stop here for now and take any questions.